Hello, everyone. My name is Duria Thanojwala, or Didi, and I'm an immigration attorney in Akron, Ohio. I practice employment-based and family-based immigrant petitions throughout the US. And first, I would like to thank the University of Akron and Robin Brown and her team for organizing this webinar and inviting me to speak today. Both Farhad Setna and I will be speaking on a wide variety of immigration topics. And specifically, I will cover the I-9 compliance process, the EVerify system, the O-Visa, the TN visa, and the firm labor certification process. So let's begin with the I-9 form, because this is literally the first form that you will fill out when you find a job on your OPT or STEM OPT, and both the employer and employee must complete this form I-9 for each employment that you would have in the United States. So basically, what is an I-9 form? The I-9 form does two things. One, it tells you the identity of the person. And second, it tells you your employment authorization. That is the purpose of the form. Next slide. And I know this is easy to you must use the most current version. I mean, this is kind of an easy answer. It's common sense, but I have frequently seen people or employers who use an old version of the form and they don't hand out the most recent version to the employee, and that form is no good. So make sure that you use the most current version of the form, and the expiration date is typically written in the upper right-hand corner of the form, and it's very easy to look at it and know that, hey, this is the most recent version. It is not the employee's burden to look at that. It is usually the employer's burden to make sure that they are using the most recent version of the form. Next slide. So what do? You, the foreign national, when you're handed the I-9, what you need to do, what an employee needs to do is first fill out Section 1. And Section 1 must be filled out on the first day of your employment. And typically you get 3 days from the start date of an employment to finish the Form I-9, present the documents to verify your identity and employment, and hand it over and save it in the HR file. As far as the Social Security number, it is voluntary on an I-9. It is not a necessity. And sometimes if you have even applied for a Social Security number and you don't have the number yet, it is okay. You can actually enter 000 on the space and you are still authorized to work. If you are an employer who participates in EVerify, at that point in time, the Social Security number becomes mandatory. You will not be able to work without a Social Security number if your employer is in the EVerify system. Again, an employee's email and telephone number, even though there is space to write that, that is optional. If you don't wish to share that information, you do not have to fill it in, and you can write not applicable in that section. Next slide. Next.
Did you want me to go back?
So, yes, I think we need to probably, should be a Section 1.
Okay. It talks about Section 1 in this slide.
And then it's citizenship or immigration status. Yep, that's it. So what do you fill out? There are 4 boxes on Section 1. The first one, obviously, is box 1 is US citizen. The second box is if you are a national or like of one of the territories in the United States. And this is, I've rarely seen this box too being checked. The third section is if you are a permanent resident or you have a green card. That's the box that you would check. And then box 4 would be the ones that apply to all the non-immigrant visa holders or the OPT, the STEM OPT that you have. This is typically the box where the foreign nationals tend to fill it out. And in this section, you can either have your alien registration number, you can submit the I-94 admission number. Obviously, the I-94 has to be some work authorized visa, such as an H1B. And the third one is where you can enter your foreign passport, which will act as basically identity information. You sign and date section 1, and you hand it over to your employer. Next slide. What are the list of acceptable documents? So remember, I-9 needs to either have identity and employment authorization. So there is a list of list A documents which establish both. They both have your identity and employment authorization. And in this section, it's either the US passport, your green card, your foreign passport, which would give your identity, or your I-94 along with that. And if you have an EAD card, so if you are on a STEM OPT or the OPT, you will receive an EAD card, and an EAD card is an acceptable List A document because it both establishes your identity and your employment authorization. If you don't have a List A document, then you can go to List B and C, and together they will form the identity and employment authorization of an employee. Next slide. Now, I'm going to cover what we call a receipt rule over here, because it sometimes will happen where you have an OPT. So you have your EAD OPT, but it will expire in 12 months. And you have applied for your STEM OPT, but you have not yet received it. Or in other cases where there is an employment authorization document that somebody has for another work visa or another work category, and it has expired, and they have applied for an extension. And that's what I call the receipt rule. In that case, under the receipt rule, an employee is permitted to work if you take the receipt to your employer and you show that you have applied for the extension and you have the underlying documents to prove that. An employer can allow you to continue work and you won't be able to miss any days. There's a huge handbook on this issue for employers, and that's the guidance that is in that book, but an employer will review that information and hopefully guide the employee as to what is the acceptable list as far as the receipt rule is concerned. Next slide. So once you have completed section 1, the employer will review everything, and then they will complete section 2. And it's the employer's burden actually to make sure that there were no errors made by the employee in section 1. And then they basically review everything and sign. Next slide. And this is a new field. There is an additional information field that was added to section 1 about 2 years ago. And this is a section where if somebody were on TPS, which is temporary protected status, or if they have applied for an extension in the TPS status, or today, for example, Haiti or Haitians have an automatic 180-day extension. It's called an auto extension of their EAD. So even though your EAD expired, they automatically get an auto extension for 180 days. So if you are an employer, this is the field where you can actually note that 180-day auto extension on the I-9, and then you can basically save that in the file. Or if you were an F1 student and you have applied for H1B and you have hit the lottery, so you would get what we call the H1B cap gap extension. Those extensions can be filled in the additional information section, and you may continue working for that employer by adding that information in this additional information box. Next slide. So what's considered an employer examination or an employer discrimination? What an employer cannot ask from an employee is it cannot specify which list of documents it will accept. So if you remember a couple of slides back, I had a list A, which proved both identity and employment authorization. And then you had list B and C, which proved your identity and your work authorization together. So you are actually free. An employee is free to look through that list of acceptable documents, and you can bring in any of those documents. Your employer cannot specify that they will only accept XYZ, like, for example, they would only take your driver's license or your social security number. You could actually go through that list of list A or list B and C, and you can bring in any documentation that could prove the I-9 compliance issue. Next slide. So this is a section which is at the bottom of the I-9 form. It's section 3. An employer typically uses this if they are re-verifying your employment. And what is the re-verification process? Again, as an example would be, a good example would be that you were on OPT and then you have applied for STEM OPT, and they need to re-verify, correct? Because you had 12 months, your 12 months have expired on the I-9. So they need to re-verify your 24 months. And this is the section where the employer can re-verify your additional employment. Or if you change status to H1B visa and you continue working, they could note the 3 years of the H1B, 3 years that you have in this section 3. For rehiring, let's say if you have left a job and you rehire, I typically advise the employer to just fill out a new I-9. I tell them not to use the old 9s for rehiring purposes, but that's based on whatever the employer's HR has in place at that point in time. Next slide. So this is an example of how your EAD card would look. So let's say you have employment authorization document, you will apply for your OPT or your STEM OPT, and what you receive in the mail from the USCIS, this is an example of an EAD card. When you apply for EAD, you typically use the form I-765, and EAD has multiple various categories in it. There are different sections where we fill out. So for example, there's C26, there's C9, depending on how you have applied for the EAD, and that would be noted on your EAD card. Next. I'm going to briefly cover the e-verification system. If you are a startup, if you are a small company and you need to enroll into EVerify so that you can hire foreign students who are on STEM OPT, obviously you need to be part of the e-verification system to be able to do that. And you would basically go to the e-verification website and you can register the employer. But you have to note that once an employer enters the e-verification system, then they have to e-verify all their employees. So it applies across the board for all employees hired by that employer in the system. And this is how the e-verification website would look like if you had to go ahead and make an account for the e-verification system. Next slide. So basically, EVerify is an internet-based system which allows businesses to determine the eligibility of their employees to work in the United States. And it is actually mandatory in certain states, but it is not mandatory in the state of Ohio. But I do know that if you work for the federal government, or there are some federal employers where it is mandatory for them to have the EVerify system. And again, it is mandatory if you have to seek a STEM OPT extension. So you need to make sure your employer has EVerify if you're going to be working for them under the STEM OPT extension. Next. So I'm going to cover something which is called the 60-day rule. And what that is basically whenever a non-immigrant status expires, so let's say the F visa, the H1B, a foreign national gets 60 days to stay in the country before they either transition to a different visa or they go back to the host country they came from. And typically, F1 visa students, which are foreign students, they are admitted for what we call the duration of status, and they get an additional 60 days to reside in the United States to basically look for maybe another job or another visa. And this is called the change of status when they go from either F to an H1B or F to O visa or F to L, whatever the status might be. Next slide. So here I would like to kind of see, because I've seen it recently happen in some of the forms where I have been applying from F1 visa to an H1B visa, where the change of status, especially if somebody is on a STEM OPT extension or a STEM OPT EAD, and they get that additional 60 days. I have seen where when we have applied for an H1B after the STEM OPT expired. So meaning if I've applied for the H1B during that 60-day time frame, then I have received what we call a request for evidence, where they have questioned that change of status H1B petition for me from the F1 to the H1B. So what that means is that you have to be careful. If you find a job, try to find it and try to apply for whatever change of status petition that you are planning to apply prior to the 60 days. Try to do it before your STEM OPT EAD is expiring. That is an ideal situation. I know it doesn't happen all the time, where you have a job lined up and your STEM OPT has expired, and maybe in those 60 days is when you apply. If that's the case, that's fine. Your H1B will get approved, but there may be a chance that you would have to get the H1B visa stamping done abroad. But that is something you should definitely consult a good immigration attorney and try to see how you could resolve those issues before you start the application process. And I cannot stress enough that make sure that you do not let your F1 visa status expire. Make sure during those 60 days, make sure that you line up either a B visa or some other visa so that you do not let your status expire or go out of status in this country. And with that, next slide. I think I'm back to Farhad said now. Thank you.
All right, thank you so much. We'll get Attorney Setha's presentation loaded here, and then he will tell us about H1Bs and more.
Hi, everybody. Can you hear me? Robin, can you hear me well?
Yes.
Great, thank you. Everybody, good afternoon to you. And I want to say, Durya, what a nice presentation. And before that, Emily, what a great presentation. Lots of useful information already to our attendees. So good afternoon, everybody. Without further ado, I've got a lot to get through. So I'm going to get started here. And we're going to talk today. Next slide, please, Robin. Thank you so much for advancing the slides. Typical disclaimer, it's only general, talk to an attorney, etc., blah, blah, blah. Okay, next. What am I going to cover? H1B process, the concurrent H1B, exceptional or extraordinary ability aliens, Schedule A, Group 2, and then maybe a little bit about investment-based permanent immigration if we get a chance to do that. Thank you, Robin. Next one, please. Okay, so quick background here. What is the employment-based immigration process? Typically, as a student, you're coming to the USA as a non-immigrant on an F visa, J visa, maybe an H, maybe something else. You get, if you're an F1 student, you'll get the OPT, which both Emily and Durya spoke about in great detail. And then once you're on that status, you may want to then seek some kind of change over to a status that allows you to work once you're done with your studies. So you may come in, you may want to then start getting changed over to an H visa, maybe an O visa that Durya is going to talk about a little bit later, and maybe some other types of visas as well that might allow you to go directly from your H visa straight perhaps to a green card application. So we've got some options for you. The employer, just remember this, students, okay? You're an F1 student. You can't do anything for yourself. To get an H1, your employer has to pretty much do everything. To get the I-140 or the labor certification approved, again, your employer has to do everything. So don't be lulled into a fact that you can do a lot of stuff. No, your employer has to do it. So get engaged with your employer from the very beginning. Tell them up front, hey, I'm on OPT. OPT expires in such and such amount of time. During that time, I need you to get the H1B going for me. H1B is in my hand now. It expires in such and such time. I need you to get started on the labor certification and the I-140 process. So employees, students, take this into your hands, okay? Stay in status at all times, and then it will lead to your green card or legal permanent resident status. Robin? Hiring a foreign national, we talked about OPT already. Both Emily and Durya covered that. Changing to an H1B. What's an H1B? H1B is the workhorse of employment-based immigration law. It's a non-immigrant visa allowing you to live and work in the USA for a particular employer. So the H1B is linked to an employer. Can you have multiple H1Bs for multiple employers? Yes, you can. We'll talk about concurrent H1Bs toward the end of this segment. What if there are no H1Bs available? Well, every year, the Department of Justice provides through the USCIS an H1B visa lottery. And the H1B visa lottery is typically oversubscribed. Last year was about one approval for every 3 applications. So you don't have a great chance of succeeding. A lot better chance than winning the lottery, but still, to someone who doesn't get that lottery, it could be a very difficult issue for their future in the United States. Can you reapply for the lottery if you haven't won the lottery in the first year? If you're lucky enough to be on the STEM OPT and you've got 3 years of OPT, yes, you can apply year after year after year. Hopefully, one of those 3 years, you'll get a hit on the lottery and you'll be able to apply for H1B. If you don't get the H1B, there's also the O1. There may be possibility of an L visa down the road as well. I won't be able to cover L's today. There's just not enough time. But in the future, we can address that issue in a more detailed seminar. Next, please, Robin. Okay, the H1B visa is a professional employment, requires at least a bachelor's degree. It's good for up to 6 years, can be extended under some limited circumstances. There's premium process option, which means if you pay an extra fee of $2,500, the USCIS will process your H1B application within 14 calendar days. Can the H1B be extended? Absolutely. As I said, it can go up to 6 years, and even after that, if certain conditions are met. An H1B transfer, you're working for an employer, excuse me, the employee wants to go to another employer. Is it possible? Yes, it is. You're working for an employer, you, the employee, want to have another H1B job. Is that possible? Yes, it is. That's where we come into the play, into concurrent H1Bs. Next one, please. What's the H1B processing like? Because of the oversupply of H1B applications and the limit on H1Bs that was placed by Congress in its infinite wisdom many years ago, were limited to only 65,000 H1Bs for all categories of H1B, any degree from any place in the world, and another 20,000 more for H1Bs applications who are to be filled by employees who have a master's or higher degree awarded by a U.S. institution. So to get into that situation where you're able to file a lottery application, you've got to first file the electronic registration. You've got to file the electronic registration, and that opens up sometime in March of each year, goes on to the end of March. USCIS will collect all those applications and supposedly run a random generation sequence on those applications and select 65,000 plus 20,000 to make the cap for the current fiscal year, which begins October 1 of each year. So even if you apply back in April, you get a chance to apply for the lottery, you won't get your H1B approval at least until October 1 of that particular year. There's only a $10 nominal fee to process your case, but be careful, students. Don't be tempted and go to 2 or 3 employers and file multiple H1B registrations for the same beneficiary. That could be a real problem. Okay, so you can certainly have different employers file for you. That's not an issue. But don't be filing multiple registrations by the same employer for the same beneficiary thinking, okay, if I buy 10 lottery tickets, I'm getting a better chance of getting a hit versus only 1 lottery ticket. It's only 1 lottery ticket per beneficiary per employer. Keep that in mind. Don't buy too many lottery tickets. It's not the Ohio lottery. Okay, next. Okay, what's needed for the H1B processing? Very simple stuff, basic stuff, information from the employee's passport, information about the employer, their address, federal federal employee identification number or FEIN. Every employer has that. Next one, please. Whether you, the beneficiary, have obtained a bachelor's degree or a master's from a U.S. institution or higher education, if a PhD perhaps, for example, registration by the attorney, if you have one at the registration process, and any additional information that USCIS needs. It's a very simple process, students. You can complete it within a matter of 20 minutes. Seriously. However, the USCIS will select applications and then will notify the registrant. Okay, only if you're notified with the approval notice can you file an H1B application. And when I say you, that means your employer, because remember what I said at the very beginning, only the employer can file the H1Bs. So you can try to shepherd the process, guide the employer, get a good attorney, and help you in the process. And that if your application is selected, you get 90 days to file the full H1B application with the USCIS. Next, please. What's the LCA? The LCA is the labor condition application. Briefly, all that means, it's a fancy word that says the employer is going to pay you, the employee, the student, or the non-immigrant worker, is going to pay the employee at least the basic prevailing wage for the position. That means the salary that's fair for that occupation in that particular geographic area. And that is certified by the Department of Labor, hence the word labor condition application. They're fulfilling the necessary conditions, among which are the need to pay the wage, that no U.S. worker is being displaced, that the employer is, fulfilling all the requirements of the U.S. Department of Labor and not discriminating against a U.S. employee. If there's any material change in your job, you do need a new LCA. You may also need a new or amended H1B petition. For example, if your location changes, of course, if you move to a different employer, you need a new LCA and you need a new H1B. Keep that in mind. Anytime you have a STEM OPT extension, a student who is in a STEM program and needs an OPT extension for the next 2 years, they have to work for an employer that is registered in EVerify. Otherwise, the system will not approve the STEM OPT 2-year extension. Next, please. In case your employer is selected in the lottery for the H1B, they file within a 90-day window. As a practical matter, I always advise my clients to start collecting information, and I start doing the research on the job, the wages, everything else, even before we get the approval, just so we have things ready to go if we do get the approval. Next, please. Current filing fees, very expensive. Okay, $460 is the base fee, the ACWIA fee, the H1B fraud fee. if there's a dependent employer, a whopping $4,000 more fee if they're an H1B dependent employer. And then, of course, the premium processing if you wanted to move faster. Next slide, please, Robin. What's a concurrent H1B? Let's say you're working on a cap subject H1B, which is an H1B that is for employers who are limited to the 65,000 plus 20,000 cap. Or you're working for a non-cap H1B employer, for example, a hospital, a teaching hospital, a university, institution of higher education, research facility affiliated with such university. Then you're not subject to that 65,000 plus 20,000 cap. So if you're working for any of these locations and you want to work for another employer on an H1B, can you do that? Yes, you can. You can file a concurrent H1B. However, be careful that you're not exceeding too many hours a week. There's only so many hours you can humanly work. So if you're going to have 2 or 3 full-time H1Bs, that's going to mean you're working all the time. You're never sleeping, you're never resting, you're never eating. It's impossible. So be careful how many hours you work on your concurrent H1Bs put together. Do you need, you also need to consider your travel outside the USA, and should you start your new employment before the USCIS approves a concurrent H1B filing. That's something very critical, and you want to keep that in mind, because if you have a job, let's say with employer A, let's say you decide you're going to leave employer A, not even a concurrent filing, leave employer A, transfer to employer B. Should you start working for employer B before you get your H1B approval for employer B? I tell my clients, let's file the premium processing and let's wait for the approval. Don't switch jobs till you get the approval, because if it's denied for whatever reason, you don't have your old job and you can't work at your new job. So keep that in mind. Next slide, please. Switching back to Attorney Duriya Dinojwala. Go ahead, Duriya, take it away.
Switch our slides over here again. Thank you so much, Farhad. That was wonderful information. And I just wanted to remind everyone also, as this is loading, that if you have any questions that you want to type into the chat, you can go ahead and do that, and we will address those during the Q&A session at the end of this. That part will not be recorded, or you can just hold your question and ask it then. All right, let me get on the right slide. Is that the right one?
Yes,
okay,
it is.
Perfect.
So thank you, Robin and Farhad. So we are going to switch from the H1B visa to the O visa now. And what is an O visa? O visa, again, is a non-immigrant visa, and it is meant for individuals with extraordinary ability. And that is defined as a level of expertise indicating that the person is one of the small percentage who has risen to the very top of his field. Next slide, please. And what are the different, basically, O visa categories? There is what we call an O1A and O1B visa, but for the sake of this presentation, I'm just going to focus on the general version of the O1 visa. And it is available for foreign nationals of extraordinary ability in the sciences, arts, education, business, or athletics. And it is a good alternative for PhD students who have done a lot of research, who have research papers, publications, or even physicians who have done a lot of research publications and who don't end up hitting the H1B lottery. And then this extraordinary ability should also be demonstrated by sustained national and international acclaim. And the beneficiaries' work in the US should also be in the area of that extraordinary ability. Next. So why consider an O1 visa? The reason you may want to consider an O1 visa is that it does not have that 65,000 annual statutory cap like the H1B visa. Obviously, if you don't hit the H1B visa, that's another consideration. You might want to look at the O1 visa. A third consideration is that O visa can be extended. It does not have the 6-year statutory cap like the H1B visa. So if somebody has finished their 6 years on H1B visa and they don't have a visa to go to, you may want to consider the O1 visa at that point in time as well. The fourth reason you may consider an O1 visa is once you have demonstrated your extraordinary ability, that foreign national then can turn around and file what we call the I-140 petition under the EB-1A extraordinary category and try to seek a green card under the same premise and the factors that they have established under the O visa category. And then there is another reason. If there is a foreign national who has been on a J1 visa waiver, and they require kind of a waiver of that 2-year home residency requirement, because sometimes physicians are on J1 visa, and to go to the H1B, they need a waiver. But if they don't want to do that, it's a very good option for physicians to apply for the O1, especially if they are going to teach in a medical school or they are going to be doing some research in the medical area, or even other J1 visa holders can look at it and see if an O visa is a possibility for them if they are on J1. Next slide. What are the eligibility requirements of an O visa? So basically, to prove an O1 visa, and it is not an easy job. Let me tell you, O1 visa are case by case analysis. You really will have to work with that attorney who is preparing your O1 visa application on all the eligibility requirements and submit a lot more evidence than you would for the H1B visa process. So you must prove at least 3 factors for obtaining the O1 visa. And the first one is, of course, a national or internationally recognized prize. And this could be a Nobel Prize or really a high award, which I rarely have seen that. So then I go down. The second one is the foreign nationals' membership in association in the field in which the classification is sought. The third one could be published materials in trade journals. The fourth one is the judge of work of others. You have reviewed somebody else's work, you do book reviews, you do paper reviews. All of these documents would be needed to prove this judge of work of others. The fifth one is that you have original scientific, scholarly, business-related contributions in peer-reviewed journals. The sixth one would be, again, authorship of scholarly articles. I have sometimes used papers in 2 or 3 different categories. And the seventh one would be that you are employed in a critical or essential capacity for an organization or an establishment that has a distinguished reputation. Next slide. You will also need expert opinion letters for the O visa purpose. And I typically recommend to my clients that obtain about between 5 and 10 independent expert opinion letters from a carefully selected pool of scholars, scientists, researchers who are actually experts in the area in which the beneficiary or you, the employee, is seeking the O1 visa. The success rate actually depends. It's somewhere around 60%. It all depends year by year as to when and how an O visa gets approved. I think currently I looked up the statistics, is somewhere between 60 and 70%. Next slide, please. So I'm going to switch to another visa type, which is the TN visa. And the TN visa is basically reserved, it was under NAFTA, and it is reserved for Canadians and Mexican citizens, and they can apply throughout the year. Again, the TN visa has no cap. It's unlimited. If you qualify for the TN visa, you can apply for it. And then you can also apply for it perpetually. There is no end time, like how the H1B has a 6-year statutory period. The TN visa extensions can be obtained perpetually as long as you can basically prove the underlying eligibility requirements of that petition. For Canadians, Canadians can obtain the TN visa at the border. For Mexicans, they need to schedule an interview with the US consulate in Mexico to obtain the TN visa. And you have to be careful if you are on a TN visa and you plan to apply for the green card. You have to time it correctly because a TN visa can be obtained for a 3-year time frame. And I typically recommend that go renew your TN visa, come back, and then restart the green card because a TN visa has an intent not to immigrate. So traveling back and forth once you have an approved I-140 green card petition might become problematic if you try to return from Canada or Mexico and you have an approved I-140 petition at that point in time. Next slide, please. So I'm going to switch over now from all the non-immigrant visas that we discussed. I'm going to switch over and I'm going to talk a little bit about the firm green card process, right? You have your underlying visa and now you have found a sponsor or your employer is willing to sponsor you for your green card. How does that process work? So I'm going to discuss with you the PERM green card process is typically applicable to 2 categories, which is the employment-based second category and the employment-based third category. Either they have a bachelor's degree or they have a master's or they have some experience, and typically foreign students fall between EB2 and EB3 for the PERM employment-based green card process. And what is it? It is in a nutshell, it's a 3-part process. Step 1 is where I prepare what we call the labor certification, and prevailing wage is how I begin. And there are recruitment steps or advertisements that you have to do. And then you have to basically certify at the end of that process by filing the 9089 form that you, the employer, did not find any US citizen or green card holders who qualified for the job that we advertised for in the recruitment process. Step 2, once your labor is certified, and this typically takes about 8 to 12 months or 6 to 8 months, depending on how fast the Department of Labor is processing the labor certifications. Once the labor certification is certified or approved by the Department of Labor, then we file the step 2, which is the I-140, which is the immigrant petition or the green card petition by the employer with the USCIS. Remember, step 1, totally different agency. It's the Department of Labor certifying. And step 2 is now you're with the USCIS applying for the actual green card petition. Once that green card petition is approved, we move to step 3, and you file what we call the adjustment of process or the I-485 packet if your visa bulletin is current. Next slide, please. So how do you begin? I'm going to I touched upon this in my prior slide. What is labor certification? Labor certification is basically a test of the US market to see if there are any qualified US workers available for the position that we are advertising. And whenever I prepare the minimum requirements, I always call it's an art. It is not a science. It is not an exact science. I actually work together with the employer and the employee to establish the minimum requirements for that position. Because, right, what is your end goal? My goal is to make sure that we can get that firm labor certified. And we have to really work together to establish those minimum job requirements so that when we receive applicants and you have a look, you have to make sure that if you find somebody, so if you find somebody who is a US citizen and green card holder, then unfortunately that step 1 9089 form at the end of that process cannot be filed. We have to stop that process. It does not mean you have to hire that US citizen or employee. We just have to stop it and begin the process all over again. So you just have to be careful, and we have to be putting in the time that is required in this step 1 to make sure that we have a 9089 certified at the end of the process. Step 1, an employer must pay all costs and fees. an employee cannot pay step 1 cost or fees, because this step is done with the Department of Labor, and they are guidelines that we must comply with during this process. So again, as Farhad was telling you, if you are a foreign student, just make sure you reach out to your employer, and you reach out to your employer's attorney, and you work together and make sure that the step 1 process is following the process that is supposed to follow, and kind of, you follow up with your employer too, because you will have no input during this time, except for at the end of that process, you will apply for this job. And if your labor gets certified, then you move on to what we call step 2, the green card petition. Next slide, please. So step 2. Step 2 is basically the immigrant petition, or the I-140 petition, which again, your employer will file for you. An employee does not sign the I-140. It is all on the employer's hand. The employer signs your I-140 for that labor cert that was certified, and you file it with the USCIS. And in this I-140 petition, it has to be for a permanent position. It cannot be like an H1B is what we call a temporary position. When we apply for H1B, the employer lists in the support letter that it is for a temporary period of 3 years. But on the other hand, when I do the I-140 letter of support from the employer, we do write in it that this is for a permanent position, right? Because you're applying for what we call permanent residency in the United States. This will not change the at-will relationship. Just because your employer filed your I-140 petition, that does not mean that an employer cannot fire you or terminate you. It still will retain an at-will relationship. And basically, if you have a contract, because there are certain positions like physicians have a contract, professors have a contract. If you have a contract, that's all employment law. So the I-140 petition does not change the employment law part of your job. They're 2 separate processes. What is the filing fee? The filing fee of the I-140 petition today is $700. And it is possible for you to premium process the I-140 petition by paying an extra $2,500 so that you would receive an approval within 15 days. And an employee can pay premium processing fees and costs if your employer refuses to pay that additional $2,500, because it's a pretty hefty fee. I mean, an employee can cover those costs, and that's not a problem. Next slide, please. How long, if you do not actually pay the premium processing fee of $2,500, then it typically will take 6 to 12 months for the I-140 to get approved. And I do this if you are from India or China, and there is no reason for an employer to pay the $2,500 or premium process it. I mean, you could regularly process it, and that should be fine. When the employer files the I-140 petition, the employer must also show the ability to pay the wage. So if you recall, in step 1, we had filed the 9089 form and the prevailing wage form, which had a wage that the employer has to pay an employee. Does not have to be paid at step 1 or step 2. You can start paying that when adjustment of status, which is step 3, is filed. But in any event, when I file the I-140 petition, the employer still has to have an ability, we call it the ability to pay the wage to that employee. So I prove the ability to pay that wage from an employer by any of these 3 methods. You can submit, an employer can submit the audited financial statements. If it's a small company, if they're less than 100 employees, then we have to do either the audited financial statements or the most recent federal tax returns with all the schedules. And if your company has more than 100 employees, then typically I take a letter from the company's financial officer or a CFO that they have the ability to pay the wage. I mean, this is an essential requirement of the I-140 petition. It has to be included when I submit the I-140 petition. And then obviously you, the employee, the foreign national would have to submit the requisite degree. So whatever that 9089 form was certified for, if we had listed, let's say, for example, at least a bachelor's degree and 24 months of work experience, then we have to collect the experience letters for those 24 months and submit the requisite degree requirement that I submitted in step 1 for the minimum right requirement to prove that this I-140 petition is approvable. And that's how we get the I-140, which is step 2 approved. Next slide, please. So once your I-140 is approved, then basically, if you have a visa available in that immigrant visa category, so it could be EB2 or EB3. We look at the visa bulletin and then I make the determination whether a visa is available in that category. And then you can go ahead and file what we call adjustment of status. That's the time you actually receive your green card. And it's the I-485 form. And we could also file it concurrently with the I-140. Let's say a visa was available at the time I'm filing step 2. I typically will put both forms together, step 2 and step 3 concurrently, and file for the adjustment of status. But what if a visa is not available? It is examples, perfect examples today are people from India and China who are retrogressed. If a visa is not available, then this step 3, cannot be filed by the applicant. Next slide, please. So what are the forms that we file for adjustment of status or for you to actually receive the green card? I typically file all of these forms together. You need the I-485. And remember, the I-485 is now signed by you, the employee. The employer has done its part in I-140. The employer does not sign the I-485 form. It will be completely the foreign national or the employee who will sign the I-485 packet. It is their information that goes into this form. What the employer gives me is what we call that I-485J supplement. That is the form where the employer will sign and say that, yes, we still have this job for this employee and adjustment of status can be done for this job. That's the I-485J that an employer will have to sign. Then you need a medical done, which is the I-693. There is the I-765. Again, that's your employment authorization document, which you can file with adjustment of status. I typically recommend we do that because if I file for that and I-131, which is advanced parole, if you need to travel out of the country and come back, I tend to file all of these forms together. And the good news is you do not have to pay a separate fee. If you file them together with the I-485, then you just pay one fee. The filing fee with the USCIS is $12.25 if all these forms are filed together, but it could be subject to change. Step 3, adjustment of status can be paid by an employee if an employer is not willing to pay for it. Next slide, please. Today, there is what we call an adjustment of status interview process for even employment-based petitions. It used to be where this was not the rule, but for the last several years, there has been an employment-based adjustment of status interview. So if you're applying in Ohio, we go to the Cleveland field office or the Columbus field office and go for the adjustment of status interview with the employee to basically get it approved. Lately, I have seen some employment-based petitions where we have received the green card without an interview. If we have submitted everything, I don't know how they make that determination, but I've seen green cards come in without an interview process too. It could be because of COVID. The processing times for adjustment of status, there is no premium processing. Remember, you could premium process step 2, the I-140 petition, but unfortunately, there is no premium processing this step 3. It is taking a very long time to get these processed. It's taking anywhere between 12 and 24 months. It depends on the field office. So it is a long time. By the time you begin step 1, step 2 and step 3, you are definitely looking at a 2 or 3 year time frame, assuming you're not from India or China, to actually receive an actual green card in your hand. And with that, back to Farhad Setna.
Thank you, Duria. And thank you, Robin, for sending those slides over. And let's get back to my slides and see what we can do to finish up here in about 8 minutes or so. I'll do that fast, get through these
Sorry,
slides.
Farhad.
Duria, you owe me lunch.
Yes, I do.
It's also people
Well,
a
we
little
can
bit
go
into our
over
Q&A
5
No,
time.
minutes.
that's all right.
fine.
That's all right. Go ahead. So let's switch back to Farhad, and there we go. Many routes to employment based. Okay, so students, listen, you don't have to be worried about just one way. If you are a PhD, if you're outstanding, if you've got publications and so on, you may have other options. For someone who doesn't, you're unfortunately limited to labor certification, which is the PERM process filed through the U.S. Department of Labor flag gateway system, or you have to go through some other route, maybe an L1. We'll talk about that just very briefly, perhaps in the Q&A if time permits. So you've got a slide here which says essentially here's your different categories, and I have at the very bottom, beware the backlogs. The backlogs are primarily for people who are born in India or in the People's Republic of China. Because if you're born there, there's so many Indians and Chinese in the line that's regulated by law, and it says essentially that no single country and no single occupation can essentially grab all of the immigrant visas for that particular fiscal year. So guess what? The line for India and China get long, and the line for other countries doesn't exist. There's no line at all, or it's a very short line. It moves very quickly. So if you have the luck of the draw to be born in India or China under EB2 or EB3, you may be severely backlogged as well. Keep that in mind. You've got to factor that in to whatever job you're doing. So you tell your employer, look, I may need an H1B for 12 years because I can't get my visa much faster. Next slide, please. Okay. What should you apply under? What category, what priority should you choose? Those are made on decisions attributed to your qualifications, the job requirements, the salary offered, Department of Labor requirements, processing times at USCIS, and again, once again, that dreaded backlog of the priority dates. So you can consider that on an individual basis. I can't give you a broad range, full spectrum analysis here. As we said earlier, this is simply a presentation. This is not advice on your immigration case specifically for you. It's just an overall presentation. Robin? Simplified steps of the EB, employment-based immigrant visa process. Obtain your non-immigrant work authorization. Maybe it's an H1, maybe it's an O. Decide, are you going to go for the PERM, which is the labor certification, or a direct I-140 if you're EB1 or EB2, national interest waiver, or the EB2 Schedule A, etc. File your applications, either the PERM application or the I-140. Once your application is approved, you file for the adjustment of status. Concurrent filing, what is it? What are the benefits? If you have a priority date which is open to you, if you're a country that doesn't have a backlog, you could file your I-140 and your I-45 at the same time. What does that do to help you? You can apply for employment authorization with your I-45. You can apply for travel authorization with your I-45. Your family members can also apply for their employment authorization, their travel authorization, and their green card at the same time as you. Are you taking a risk? Yes, you are. But is it a calculated risk based on your ability, your efficiency, the type of case you have, the quality of your presentation, and the background that you possess? If you have all of those things in the positive, it's more likely than not going to be approved. So it's a great investment to make to be able to file concurrently, and that way preserve and protect not only your own rights as an immigrant for employment, for travel, and for continued status in this country without waiting on a non-immigrant H1B visa or some other type of visa. And also, more importantly, that of your family. You may have a spouse who's sick and tired of sitting at home and watching your kids. Okay, she may be able to, or he may be able to actually now work legally. So all of those things factor into whether you should do a concurrent filing or not. Robin, next please. I've got 3 minutes left, so I'm going to really just skip by this slide altogether about priority dates. It's a very arcane topic, but we can avoid it for now. Thank you, Robin. Next slide. Immigrant visas. We talked about this a little bit in the earlier presentation by Duria. Requires the PERM application, filing for labor certification. Once the PERM is approved, you'll file your I-140 with the U.S. Department of, with the USCIS. And then that I-140, once approved, leads to the adjustment of status or green card application, again filed with the USCIS. Go ahead, please, Robin. Okay, can you self-petition? Absolutely. If you're an alien of extraordinary ability or an alien of exceptional ability and your work will be in the national interest of the United States, you can absolutely self-petition. You don't need an employer. What does this need? Next slide, please, Robin. You need major prizes, international awards, national awards, membership in professional associations, your own publications, work written by you about others in professional publications, other people writing about you in professional publications, judging the work of others, and original contributions to the field. If you're going for a I-140 EB1 as a outstanding professor or researcher, you must have either a tenure track position with a university or institution of higher education, or be a researcher with a private company or a public institution which hires at least 3 researchers. So those are the parameters. Please continue, Robin. Multinational executive manager, that's another wonderful way to get a green card. If you're an L1A, not an L1B, an L1A can get a green card by virtue of the fact that they're a multinational executive manager. It's job creation, payment of taxes, show managerial or executive nature of the position. Just keep in mind, it's a highly scrutinized set of facts, but if you meet all the boxes, you fulfill the regulations, you can get a green card by being an L1A. It's generally not suitable for smaller companies, but the advantage is it avoids the PERM process, and there's also no prevailing wage requirement as there is for the labor certification for the PERM process. Next slide, please, Robin. Okay, immigrant visas. The national interest waiver. The national interest waivers, as the name suggests, means your work is in the interest of the nation, of the United States. Consequently, the U.S. Department of Homeland Security, USCIS at this point in time, waives the need or discards the need for you to obtain labor certification. That is, go through the PERM process. It's a wonderful and useful method for people who may not be at that extraordinary level, but still have exceptional enough skills in the national interest. Next, please. Okay, there's also Schedule A groups 1 and 2, which are for people with shortage occupations, which are at this point in time professional nurses and licensed physical therapists. There's also group 2, which essentially almost looks like the O, or outstanding ability alien, who can qualify for permanent residency with the direct filing of the I-140 if they qualify for Schedule A Group 2. Next slide, please. And that is what I'm talking about, Schedule A Group 2. We'll avoid all the dense text because I'm pretty much out of time at this point in time. Next slide, please, Robin. The investor visa must either invest $1.8 million or $900,000 if you're in a targeted employment area where there is high unemployment, must create 10 full-time US jobs. It's a conditional status good for only 2 years, after which you can apply for full legal permanent residence. Why is that important? Because most immigrants, in my opinion, are really entrepreneurs at heart. So See if that qualifies, see if you can do it. And if you can't, and if you're coming from a country that has a treaty with the United States of friendship, commerce, navigation, investment, etc., you may be able to get an E-visa, E for elephant, which is a long-term visa, no limit on number of years, for investing in the USA or trading with the USA. Next slide, please. Statistics about immigrant investors, encouragement essentially to some of you who may be out there who have that investment bent in your body, who want to go in, contribute, invest. You've got dreams, you want to create the next Google, go for it. I encourage you. Next slide, please. What am I advising my clients? Try for an H1B. If so, go for a higher level of wage. If you're applying for an H1B again, the job description must be higher than for an entry-level position. Try to make it a higher level job so that there's not a criticism that the job doesn't need a professional. The adjustment of status may be an interview. If it's an employment-based petition, as we already heard, that's something to be aware of. And there's a form I-245J, which is essentially, once again, qualifying you as an employment-based, making sure that at the time of your adjustment of status, you're still hired by that petitioning employer, or you're working in the same or similar occupational classification. Next slide, please. Thank you for attending. Here's my name, here's my address, here's my phone number. If you have any questions, call me or email me later on. And back to you, Robin and Emily and Jung, for the Q&A with Duria. Thanks so much.
Thank you so much, both of you, Duria and Farhad. Wonderful information. We're looking forward to the Q&A portion. And Jung is going to kind of facilitate that. Again, you can put questions in the chat. You can also use the little raise your hand icon that's at the top of the screen, or you can just turn on your mic and ask a question. I don't know if we have many questions in the lineup yet. So while we're waiting on questions, I will see about, I'm going to go ahead and post the PowerPoint slides in the chat so if people can, kind of review those. And also, if our attorneys at some point, if you want to type in your email address or any contact info into the chat also, just so people have it, that would be great. So go ahead with your question.
Yeah, so I know you guys have been sitting for a little bit. It's definitely a valuable information, but if you guys want to just